So, good evening, everyone, and welcome to our February Rights at Night session. I am Lisa Morgan. I'm a kindergarten teacher from DeKalb County, and I am currently your GAE president. We have been doing Rights at Night this year. We started back in July with issues around COVID, and we've had these monthly since July. If you missed a session and you are interested in going back and seeing that information, we have done social media and First Amendment rights. We have done teacher retirement system. We have done the strategic waiver school systems. All of those are on the GAE YouTube channel, and I will put that in the chat. So you can go back and watch any sessions that you may be interested in that you have missed. We are recording our session this evening, and it will be placed on the GAE YouTube channel as well, so you can share with colleagues who are members who may not have been able to join us this evening. This evening, our topic is our teacher contracts. I know that many of the districts here in Georgia have issued your contract offer for the 2021-2022 school year. So this is right on time for us to learn more about the contract and our rights and obligations under Georgia law with our teaching contract. So at this point, I would like to introduce to you Mike McGonigal. He is our GAE General Legal Counsel and works hard every day to protect our members and to help them through the process when there are issues with their legal rights. Mike?
Excuse me. Thank you, Lisa. So I'm going to do some slides, do some screen sharing, go through some slides, and I think when we get questions periodically, Lisa can ask them or we can take them at the end, however we want to do that. So let me get this going. And I need to start from the beginning. There we go. Answers to commonly asked questions about teacher contracts. So I always want to begin any sort of legal presentation about a reminder of the benefits you have of a member that you can share with potential members. The first area is employment liability protection, and everyone says ours is the same as other organizations. That's not true. Other organizations offer up to $1 million in liability protection, where the NEA GAE liability protection goes up to $3 million. You can see that also the attorney's fees and costs also is substantially higher than other organizations have as well. But that's not the most used portion of our legal defense program. The most cases we have are under employment defense certification defense. And so the most important to keep in mind really is that we have no predetermined cap on the amount of legal fees and costs that we expend in defense of a member. Other organizations will cap your cases. They will aggregate defense of criminal case, employment, and certification. And if it goes over a cap, they will no longer represent you. We don't have that approach with NEA GAE. And also major distinction is that we file affirmative lawsuits against school districts. And those cases routinely can go be $25,000, $50,000, and a whole lot more. And we'll get into some of these cases later on in the presentation. But I just always want to remind folks of what you have as a value of membership. And when we're out promoting GAE NEA to potential members, this is one of the areas that we can attract folks and keep them as members. I thought about, I've done these contract presentations before, but it hit me the other day that I've not really touched a whole lot on at-will employment. And I thought I would just spend a slide on at-will employment. And of course, those are our ESP members, our bus drivers, our janitors, custodians, our secretaries, who work hard every day, who don't have contracts. And there's an interesting case I just became curious about, because I had always heard Georgia is, behind the times. And so I looked at it, did a little bit of digging, and there's a case that's a pre-Civil War case that is still good law in Georgia. As you can see, it's 1853. I think the math on that's 168 years old. But the point of that case was, if you don't have a contract for a definite period, it's an at-will employment contract. In a teacher contract, you have a definite term of, typically 180 days. That's your term. If you don't have that, you're an at-will employee. And as you can see, the plantation overseer sued the plantation owner to recover wages, and the Georgia Supreme Court said there was no definite term to that contract. So he was just a paid laborer. He worked, he got paid, and there was no expectation of payment of those wages beyond, the day's work. The second piece to the slide is the statute in Georgia, the labor statute, Title 34. And that basically codifies this 1853 case. You can read it that if you don't have a contract with a definite term, if your terms are indefinite, then you're at will. So you can see the common law doctrine established way back in 1853, codified in Georgia statute as good today. And of course, none of this means that it's written in stone forever. The at-will employment doctrine can change through political advocacy. If we elect enough people to the state house to amend that particular statute, we can change things here in Georgia. Alternatively, your local Board of Education can adopt a policy so that our classified employees can have more job protections. If not a contract of employment, they certainly deserve more job protections, just as our teacher members do as well. Oh, that's my, trying to resuscitate this old law. I forgot my little thing there. So just another word before we dig into contracts per se is that we're living in this era. I guess it's called education reform, but I don't know what type of reform era that we're in, because every school district in Georgia must be one of three models: a traditional model where all of the education laws apply, all of Title 20, or it must be a strategic waiver school system where the school board can pick and choose which of our education laws they don't have to follow. And the third one is the charter school system law, where again, the local Board of Education has entered into an agreement with the state board to waive all of the Title 20 education laws with a few exceptions. And as you'll see, the concept behind this reform is that in exchange for waiving supposedly onerous state laws, education laws, student achievement will skyrocket, or it will improve. And you can see, I say Scouts Honor or We Promise, because there is no data to show that increasing class size improves student achievement. there is no data showing that waiving the state salary schedule improves student achievement, or waiving certification standards has any causal connection between that and increasing student achievement. And so we are all in this fight together, and your locally democratically elected, school board can amend your charter agreements, strategic waiver or charter school system. So a little bit of homework for those who don't know. You should go to find out, is your school system that you're working in a charter school system or a strategic waiver system? And keep in mind that whatever that has been waived by your local Board of Education, can be unwaived if there's a political will to do so, and we elect enough people on local boards of education that are willing to do so. And last but not least, the General Assembly can also reform or restore your rights. And there's currently a bill pending, and Lisa will have the bill number. It's a House bill that State Representative Rebecca Mitchell is the main sponsor of, that proposes to restore your rights that have been waived by the strategic waiver school systems as well as the charter school systems. And as we'll see in a moment, that this will have an impact on teacher contracts. So here's one of the, as we get into it, what GA can do and has done for us and will continue to do, is that we filed a lawsuit back in the late 80s, got a decision in 1990, trying to establish what the statute of limitations is for a teacher contract. And the Court of Appeals came back and ruled in our favor that a teacher contract has a 6-year statute of limitations. And so what that means is that if you have been underpaid for whatever period of time, 2 years, 4 years, whatever the case is, we can recoup up to 6 years of your back pay for the period of time that you were underpaid, okay? But we can't get more than 6 years. The flip side of that is that if you have been overpaid, that's going to be an issue that we will represent you on. But just keep in mind, a school district would have a claim to recoup the overpayment of your salary for up to 6 years. I haven't seen a case that extreme in my time, but I've seen a few situations where folks have been overpaid, and we've been able to avoid litigation and work out a settlement. And I just always, I throw in that state or school districts cannot waive court decisions, but as a person who wants to see equity in public education, they didn't waive Brown versus Board of Education, but at the same time, it has never been fully implemented. And on that point, I do want to recommend a book to you. It's called The Lost Education of Horace Tate by a Vanessa Siddle Walker, who's a professor of education at Emory. For those who don't know, Horace Tate was the first African-American executive director at GAE. And the book details his upbringing and life in Jim Crow, Georgia, and what he and his wife had to face as violent resistance to Brown versus Board of Education, and the years that led up to the merger between the Black educator organization and the white teacher organization in Georgia, which resulted in GAE. The name of the book again is The Lost Education of Horace Tate by Vanessa Siddle Walker. So basic law, we're going to run through these. These slides have a lot of words in it. I apologize, but I feel that You can copy this and refer to it if you need to. So the law says teachers, principals, and other certificated professionals are entitled to written contracts. Now that law, although in concept may have been granted flexibility or a waiver in all of these strategic waiver systems or charter school systems, in practice, there is no district that does not offer written contracts. Of course, you always want to read it before signing it. Lisa had alluded to districts are already coming out with contracts for next school year, but the issue there is there's no law that tells school districts how soon or how early they can actually offer a contract. And so there's another opportunity that we can approach our representatives at the State House to put a definition or a time limitation on it that they can can't offer contracts, say by at least March. I mean, we have to push back on that. The statute also says that letters of intent are not legally binding employment contracts. GAE specifically lobbied for that language to be put in maybe 10 years or so ago, where a number of districts were interpreting a letter of intent. I'm going to return for next year, signed Mike McGonigal, as a binding contract. And while we never had to file a lawsuit over a letter of intent, because every time we challenged it, a school district would back down once the lawyers got involved and you got beyond the layers of administrators. They would agree a letter of intent's not a contract. But we thought, why don't we amend the statute so we can, focus on more important things than letters of intent, and trying to put a stranglehold on folks through that mechanism to keep them with the district through a letter of intent. It doesn't seem to be as much of a problem really as it used to be. I think districts now, you can tell me through the chat if you get letters of intent these days, or are they just putting the contracts out in front of you to sign? So another interesting feature about contracts is statute says your contract has to be complete in all terms, and including, and this is the language that's always been a kind of a sore spot, including the amount of compensation to be paid during the ensuing school year. So what that means in practice is that when contracts come out, if they come out right today, the General Assembly has not adopted a budget for the next fiscal year. Your local Board of Education has not adopted a budget for the ensuing school year, but they want you to sign a contract agreeing to the amount of compensation. And that language, in my mind, is a placeholder, because that what you will see on a contract at this time of year is not a numerical figure or a number, $67,819.87. You will see Mike McGonigal will be paid on X number of years of experience at a, L7 certification level or something like that, which is passable since the budgets have not been fixed at the state level or the local level for next year. But our recommendation is, once the budgets have been adopted for next year, assuming you sign the contract, you have every right to go to your principal or human resources or your bookkeeper, central office, and ask them to put in writing to you the specific number that I'm going to be paid, right? The, $67,918.42. You have every right to request that once the budgets have been put in place. Your contract is with the school district. It is not for a specific school site or location. That can come into play, with lots of shuffling at the beginning of the year, or you don't want to be transferred out for whatever reason to another school location. The law is real clear that teacher contracts are with the district. They can assign you to whatever school they want to for the good of the school system, and courts generally are not going to second guess a school board on that. Now, here's an important point. If you receive a contract, you have a minimum of 10 days to review it. The 10 days is by default measured as calendar days, unless your local board policy defines 10 days as 10 business days. Now, I throw this little in, and the OCGA 20-2-942 is where we find the 10-day contract review period. But the 20-2-942 is in the fair dismissal law, which again is a law that many school districts have waived, but I have not seen them waive, in my experience. I haven't seen a district waive the minimum 10-day review period, but it's something to be very aware of, do your homework on. If you get your contract, and if it doesn't say, if they don't have a cover letter attached to it saying you have 10 days, you most definitely have to ask, when does it have to be returned? And if they say by tomorrow, you say, no. I mean, there should be a minimum 10 days in place. So please be sure to check on that when the contracts come out. How long do I have to review it? Do I have to have it in by tomorrow? The chances are that's just a convenience for the principal. For whatever administrative reason they're running behind. They just want you to sign them, get them in, and be done with it. That generally is not how the law operates, but you got to look for the policy, and it should be minimum 10 days. So, here we are, contracts are coming out, but actually the districts have to offer a contract by May 15th. The superintendent can offer a written notice of non-renewal that has to be postmarked by May 15th as well, that he or she is not being recommended for the following school year. And so what happens, excuse me while I turn a page here, probably getting ahead of myself. So what happens if you don't receive a notice, a letter of non-renewal signed by the superintendent by May 15th? Then the contract is automatically renewed unless you notify the superintendent by no later than June 1st that you're not going to accept employment for the next year. And we'll see how all this comes together on the next few slides. Now notice here, I'm putting in a very important date from the Professional Standards Commission. The Professional Standards Commission will not sanction a certificate, and there's a typo, if the resignation is submitted prior to June 15th. So even though the state law that governs school districts basically what it's saying is you can get a release granted from your contract for next year if you submit that request by June 1st to your school district. The PSC actually has gone a couple of weeks further, so that's really in our favor. And in a couple of slides, you'll see the PSC has a long list of breach of contract guidelines. And this particular guideline that they won't sanction you if you are granted a release prior to June 15th. So that really comes in handy if you need it. The last bullet there, that was some language that was put in when Governor Barnes took away fair dismissal. If you remember, when Governor Barnes, a reform type Democrat, he introduced the A+ Education Accountability Statute of 1999, which began the standardized testing mania that we're currently hopefully seeing on the tail end of that here in Georgia. But he also abolished the Fair Dismissal Act. Well, GA opposed that all the way through, and we did not agree with this particular language, which other organizations said that's a fair compromise. And the compromise was, if you didn't get a notice, if your contract was not renewed, you can always ask for a written explanation of why your contract was not renewed. And again, GA did not, we still don't agree with that under any circumstances as a compromise for abolishing fair dismissal. Other organizations did, and they were proud of that language. My 2 cents on that is be careful what you ask for, because a couple things, you're potentially asking the district to create a negative document. Mike was a horrible teacher. He didn't do this, he didn't do that. And so now I'm stuck in my personnel file with a negative document that may be extremely hard to get rid of. So I always be careful what you ask for. If you just get a one-liner from the superintendent, your contract is not being renewed, you have a right to request reasons, but just know you're asking them to potentially create a negative document, and not a whole lot of viable options to have it expunged or effectively rebut it. So a little bit more about those folks whose fair dismissal due process rights have not been waived in Georgia. It must be served on you by certified mail. It cannot be in regular mail. Must contain a conspicuous statement of your due process rights, and it has to be signed by the superintendent. So in some situations, you'll see maybe a letter or memorandum from a principal, Mike's principal, and Mike gets a letter from the principal saying, Mike, we're not renewing your contract for next year. And this applies whether Mike's a first-year teacher or he has fair dismissal rights. It must be signed by the superintendent or it's invalid. And we have successfully challenged those particular attempts to non-renew folks when the notice has not been signed by a superintendent. But assuming they follow fair dismissal requirements, then you would have 20 days after the notice was mailed to you to request a hearing. in some occasions, a member will get a notice of certified mailing, at home, and never go to pick up the certified mail. And the law is real clear that it is the 20 days to request a hearing begins not when you pick it up. It begins when it was deposited in the mail. And so if you don't, if you get the green card, you have a certified letter at the post office, don't ignore it. That tactic will not work. The law is real clear. 20 days begins when it's deposited in the mail. So there's a big distinction between a resignation and a release from your contract. An educator must obtain approval from the superintendent in order to be released. And you should refer to your contract to see if there is a provision, how many days advance notice you must give to the district in order to be granted a release. And, the distinction is, or the important thing to realize, a release, we don't have a right to a release. It's a grant of a grant of a right to a release from the superintendent. Now, a resignation, on the other hand, is a unilateral act. It doesn't, in my view, it doesn't take anything more than a letter from me, I, Mike McGonigal, am resigning from my employment, effective, immediately, or whatever the case is. And I can go on and bank on the fact that I have resigned. I'm not saying do that. I'm trying to draw the distinction or highlight the distinction between the legal difference between a resignation and a release. Should an educator leave the school system without obtaining a release, the PSC may suspend their certificate for 90 days for breach of contract. Breach of contract, that's standard 9. I'd advise everybody to take a look at that. But I see on the next slide, we can dive right into what the Code of Ethics has to say. And this was amended, I think 2 to 3 years ago, perhaps, where we went from the previous language, it was called abandonment of contract. They modified the language, dropped the abandonment language, and went to this concept of breach of contract. And there is what the Code of Ethics says, how it defines breach of contract. When I fail to honor a signed contract with a school or school system by resigning in a manner that does not meet the guidelines established by the PSC. What you can do is go to the PSC website, and at the top of the web page, you'll see a prompt for ethics, and then a drop-down menu. Select resources, and you'll find their guidelines for breach of contract. And it contains a long list of things that they will look at and not sanction somebody if they don't, if in a situation where they leave without a release, and it could be, health reasons or a spousal move out of state, or, there's a list of things that you should take a look at. And importantly here's that June 15th date again. The PSC will not sanction a certificate if the resignation is submitted prior to June 15th. Remember that and keep it in mind. School districts will hold you to a June 1st date. that you can resign without penalty. The Professional Standards Commission says June 15th. Common problem in these situations, particularly after June 1st or after June 15th, really, is, well, we'll release you, Mike, but we have to have a suitable replacement for you. And too many times that's an open-ended question. And I might have an offer, I might work in, I don't know, McDuffie County, and I get an offer over in Richmond, and it's only good, you know, for a week or a few days or something. And McDuffie County is saying, well, we'll release you, but we have to find a suitable replacement. That's a very, very difficult position to be in, particularly if the receiving school district will only accept a release from your current employer, right? And so they've got you between a rock and a hard place. If the place you're wanting to work is colluding, if you will, and will only accept a release, there's not a whole lot that we can really do. There's not a whole lot we can do. On the other hand, if the district that I want to go work in will take a resignation, I'm good to go. I'm good to go. And, you know, I'm willing to, you know, wait, help you transition for suitable replacement. But if where I want to go will accept a resignation, then everything will be fine. So a few, some more school reform law here. So both through statute and through PSC rule, both state that if I have two unsatisfactory evaluations unremediated in my certificate cycle, right, then I'm not going to get renewed. My license won't get renewed. No, and there's no appeal process, and that's why I have this really sort of, the guy's having a hard time. He doesn't feel so good about that. So they won't renew your certificate, and there's no appeal process. How unfair can that be, particularly where we all know I can get an unsatisfactory rating because really principal doesn't like me, doesn't like my attitude, whatever the case is, they can find a reason to rate me ineffective or give me a needs development. And, you know, again, it would be based on, personal reasons or personality type reasons, not based on objective data. And unless there is shown remediation in those ratings, the PSC will not renew the certificate, and you're effectively banned from the profession. That's another piece where we have advocated that the PSC and the General Assembly would have to adopt a statute establishing a way back into the profession. Because I can say there are folks who have been unfairly treated, have been put out of the profession, and can show remediation, whether they're taking graduate classes or they're doing, some other coursework, and they can show that they've addressed their real or perceived weaknesses. But to this day, the PSC has not granted us those rights as a pathway back into the profession. So what we are doing at legal is a couple things we're doing as we do historically, doing to fight back on education reform, or in this particular case, our rights to speak out under the First Amendment, rights of free speech and rights of association, which these days we know are extremely important. And it's one thing for our members to know and potential members to know, and they can be very confident of that, gee, if you speak out within the guidelines of the First Amendment and you're retaliated against, there's no other organization that will stand behind you or will have the resources to do so. And this is what we did with the Walker County Board. Interesting thing there in Walker County is that superintendent's a member, and when we filed suit, he called me mildly upset, to say the least. But if a member's rights are wrong, and the person who's doing, taking the adverse action against a member who is the victim, it doesn't matter if the person who is taking the adverse action is a member or not. What's wrong is wrong and what's right is right. And we'll continue to do so. Okay, I got the little dance there. So we're also fighting in the courts to restore your Fair Dismissal Act due process rights. And this is just a quick tour of actually NEA sponsored litigation. NEA has a fund called Significant Impact Litigation, and they have funded 3 cases involving, waivers. The first one we did was against Atlanta public schools and their whole, their turnaround plan in Atlanta. That's probably 5, 6, 7 years ago now, where the school district implemented a plan to turn around I believe it was the Carver High School cluster, and just turn that cluster into charter schools by a board vote. And our argument was they did a backdoor run around the state charter school statute that says if you have an existing public school and you want it to become a charter school, there's a whole set of democratic procedures that you must follow. Atlanta didn't follow that. And unfortunately, we lost that particular lawsuit, but we kept fighting. And 2 cases are still pending in the court system. The Floyd County charter system case began probably about 4 years ago, and it is still pending. And it's all about, can a school district waive fair dismissal rights for those who have acquired them before they became a charter system? And I say pending, well, I want to say in late December of 2020, the Superior Court there finally got around to issuing a written decision, basically saying that you could waive fair dismissal for those who acquired those rights before becoming a charter school system. And we have the same case, or the same issues, I should say, pending against the Fannin County Board of Education. And these are very, very, very important. They involve, can you waive the Georgia Constitution? Our position on it is, if you've acquired rights of fair dismissal before becoming a charter system, then you have a constitutional contract, number 1, that cannot be impaired. And number 2, you cannot retroactively apply that law to someone who has acquired those rights. And in the Fannin County case, we had a really significant remand order from the Georgia Court of Appeals last fall that remanded the case from the Court of Appeals back to the Superior Court in Fulton County. And it basically gave that court a roadmap to restoring fair dismissal rights for those who had acquired them, excuse me, before the district became a charter system. And so the courts, they are slow as molasses. They move like a glacier, glacier upon glacier. But we're really optimistic now that in our next round of appeals, particularly in the Fannin County case, that we will have fair dismissal rights restored for those who had acquired them. So stay tuned for that. Here we go, resuscitating those fair dismissal rights again. So back to contracts. So we really like this case. We slow trend in Georgia, or slow or fast, however you want to define it, is what districts are doing to address the teacher shortage, right? Rather than improve your working conditions or pay you more or do those things, we've been seeing more districts put in your teacher contracts this thing called liquidated damages. Now, that is two sides to a coin there. Now, the district is going to say that $750 that they had in DeKalb was to cover the cost to find my replacement, right? Now, it's going to cost $750 to replace Miss Bettis and Miss Hine. We take the other view of that, that is purely punitive, that there is no rational basis upon which the school board or the superintendent arrived at $750. And so, and that's been a pet peeve of mine since I think I started with GAE. And we're always on the lookout for, test cases. And this is one where we decided to file on. And so we challenged their liquidated damages in DeKalb Superior Court. And the court came back after we did all this discovery. We put Michael Thurman under oath and asked him, how did you come up with $750? He didn't know. Put the human resources director under oath, asked her, how did you come up with $750? She didn't know. So it was a number, as we all know, that was a number they plucked out of the air. But we called them on it. And so we got $110,000, court administered reimbursement. And of course it applies to GA and non-GA members. There's no way we can control something on that scale just for our own members. But most folks got their $750 back. And they agreed to a moratorium on liquidated damages for the subsequent year. And I know President Morgan can tell us if they're still honoring the moratorium. And we also got, $50,000 in attorney's fees. Now there's that point again about what organization are you going to join and what value do you get? Miss Bettis and Miss Hines, they didn't have $50,000 to get back $750, right? Who would do that? Well, your professional organization, GAE, can do things like that. We may not win, but this is a huge win that we have begun to use in other districts like Griffin-Spalding. So this was our latest lawsuit on liquidated damages. And so Miss Jones and Miss Clark, again, they wanted a release from their contract. Griffin-Spalding said, fine, we'll do that, but you have to pay us the $750 from their paycheck. That case has settled positively. But the interesting thing there was after we had filed, we had done, the answer, we had come upon terms of settlement. We didn't hear back from the school district for about 6 months, and so we filed a motion to enforce our settlement agreement. And at that point, the school district said that GA had declared war on the school district and that we were not a professional organization. And they threatened to take away our payroll deduction because we were not a professional organization. I don't know about you, but if we are in court vindicating, fighting for member rights, I think that's what we are supposed to do. And I don't think it's a matter of being professional or unprofessional. I think if the shoe was on the other foot, I think they would say, yeah, you should file suit. And you shouldn't threaten to take away our payroll deduction. And at that point, I let the NEA know what was going on at that point, and they immediately jumped in with another significant impact litigation against Griffin Spalding schools. And we claimed successfully that they were violating our rights of free speech. A lawsuit is a form of speech. And since it was filed, GA is a plaintiff, they're retaliating it based on our associational rights. And so within, I don't know, days maybe, they rescinded this threat of taking away our payroll deduction. But the case is still proceeding because from the time they made that threat to the time they rescinded it was about 3 or 4 months. And in that 3 or 4 months time, we had all kinds of GA employees and local members in Griffin Spalding that were contacting members and convincing them to change to another method of dues payment. And so that's the harm to GA. I spent hours, our people in membership spent hours on this. Our Uniserve directors worked hard. And our members, most importantly, our members in Griffin Spalding spent a lot of time phone calling and emailing and using the Hustle app and whatever other methods they did to get the word out that they needed to change over from payroll deduction to, say, bank draft. And so those are the damages that were incurred by GAE. And so that's still playing out in the discovery phases. But we're very happy that the district saw the handwriting on the wall and decided not to take away payroll deduction method of dues deduction there. And it also serves as a warning to other school districts that if GAE is going to come in and file suit, and if they want to try to threaten taking away our payroll deduction, we will come after you on that particular retaliation claim as well. So the word is out there, definitely for sure amongst school board attorneys. So that's really it for my slides presentation. But we're definitely stronger together. Hopefully through these slides, you can see that GA has superior legal services, program, and protections for you, whether it's First Amendment, free speech, association, or even when we're taking the fight on liquidated damages. I would just add, we have approached the General Assembly in years past to ban liquidated damages, but it's fallen on deaf ears. And so when the legislature is not going to be responsive to that, then we really do have to resort to the court system to get our relief. So with that, President Morgan, is DeKalb honoring the moratorium on liquidated damages in your district?
There has not been a liquidated damages contract clause in my contract since we sued. Have not received a contract offer for next year yet, but you know that is one of the first things I will do is look to see if that clause is there. We do have some questions from some of our participants this evening. And the first thing let's break this down very step by step. You know me now, I'm a step-by-step person. So step one, when I receive the contract offer from my school district, I heard I need to read the contract. Every word.
Every word.
Every word. Okay. Read the contract. I have 10 days to decide if I am going to sign it or not sign it.
Calendar days.
10 calendar days. Okay.
That means weekends. Don't ask me why. But.
Okay. 10 calendar days. So, okay. Next thing. What if I don't like one thing in it? What if they try to sneak that liquidated damages clause back in? Can I say I don't like that and mark it through it?
Well, you can, but contracts in Georgia, I mean, you know, here, I don't have to tell this group, but they're take it or leave it. Now, something like a liquidated damages provision, you know, we can fight that on the back end of things. I would not recommend striking through and signing it. The district would be within their right, arguably, that is a rejection of an offer, and then you would be without any job.
Okay. So the next question, after I sign it, day 1, day 10, anytime in that time period, I've signed it. When is the contract legal and binding?
That's a great question. Legal and binding, ultimately, when it's approved by the Board of Education's vote, which comes after you sign it.
Okay.
Okay.
So I know so when I first started, we always got a contract. We got a copy back with the superintendent's signature, and I'm sure it was stamped.
Mm-hmm.
So that was after the board had approved them. Okay. So make sure I remember this correctly. If I sign it, because they gave it to me now in March or February, I sign. I later decide, no, I want to go to a new district. I must resign. The district's going to tell me by June 1st.
Mm-hmm.
The PSC says June 15th.
Mm-hmm.
Okay. I resign. And they send me a release of contract in my school email. I think the first thing I need to do is print that out.
I agree.
Okay. Because they're going to turn my school email off because they've released me from the contract. So make a copy, forward it to myself, print it out.
Take it home. Right.
Okay. Here's our questions from other participants. If a teacher is on FMLA, when should they receive their contract?
Well, I think there's like 2 basic approaches. If you're out on FMLA, the district might be trying to hold your contract until you come off of FMLA. If that's the case, if it was me, I guess I would go to the district and say, I'd like to sign my contract. Now you cannot be let go, terminated while you're out on FMLA leave. But, you know, for pure peace of mind and doing, you know, good HR practices, you can get a contract while you're out on FMLA. I I mean, there's nothing prohibiting that at all.
Okay. Next question. And we've dealt with this with furlough days in the last couple of years. What is the recourse if a district reduces your pay after the school year begins?
Oh, well, remember we said read every word in your contract?
Yeah.
Oh, I know you have.
Every year.
Well, I wish I had a standard contract in front of me, but I can kind of paraphrase the language which is most hurtful to us, which is my salary amount may be adjusted upward or downward depending upon receipts of, tax collection receipts, or what we get from the state, or what we're taking in locally through tax receipts. And that's, it's been challenged, but that it can be adjusted upward or downward depending on the financial situation of the school district.
I actually just opened my last contract and the salary line is 3 lines, and then all the clauses for how they can reduce the contracted salary is like 15 lines. So
Good argument for a negotiated contract. What's the other word for that?
collective bargaining.
Collective bargaining. That's right.
Okay. The next question, and this is one that I'm excited to answer because this is one of the myths that all our members have. How does tenure affect a contract, or does it? And I will say, we can do this as a chorus, Mike. We don't have tenure in Georgia.
Correct.
When you sign your 4th contract, if you're not in a charter system and if your strategic waiver system hasn't waived it, you have fair dismissal rights.
Yes, the word tenure doesn't even appear in the Fair Dismissal Act as it applies to teachers. When they abolished fair dismissal for administrators, there's that section in the fair dismissal applying to administrators where that word tenure appears one time. But in the original Fair Dismissal Act, the word tenure doesn't apply.
Okay.
Yep.
Okay. So, but let's remind everybody, if you do have fair dismissal rights and they do not renew your contract, because this was what I learned tonight, they have to send you the letter, certified mail, and your right of appeal is 20 days from the day they mailed it.
Yeah.
So if you pick it up on day 21, you're out of luck.
Very hard to undo that one.
Okay.
I can't tell you how many times I've gotten the call from a member on day 19 or day 20, which is fine. We can pull that one out, but day 21, unless we have an extremely good reason.
Okay.
Yeah.
Okay. My advice, I'm not the attorney here, but if you get the green card and you know you haven't received your contract, go get it that day and call GAE, call your UniServe director immediately. Okay. Those are all the questions we have. Do we have any other questions? If you put them in the chat, be happy to answer them. And I'm not seeing a lot go in the chat. So I'm going to thank you, Mike, for that. I learned something tonight, so I know everybody learned something. It's the best kind of presentation we have. Thank you all who were joining us tonight, who participated. We will have the recording up on the GAE YouTube channel, so you can send your colleagues who weren't able to join us this evening here. If you have colleagues who are not members yet, please ask them to join us. Join GAE.org. And thank you all for being with us. Next month, our Rights at Night session will be on March 23rd, and that one will be about all of our federal issues with 504 plans and IEPs and those kind of issues. And we will have an outside attorney who is an expert in that to do that presentation for us. Wednesday nights, we do have Facebook Live on the GAE President's page. Thank you all for attending this evening, and you all have a great rest of the evening.